Good morning. This is the first seminar of this year's seminars on European and international taxation. And we are very pleased to welcome Ricardo Regada Pereira, who was the lawyer in charge, or one of the lawyers in charge of the Secil case. I would like only to mention the judge of this case, the Portuguese judge. She's a judge of first instance court. Her name is Margarida Reis, and she was very bold to refer the case. She's also a master's student at our university, so I think it's really a big moment for Portugal, for our university, for the lawyers of the case to celebrate now the decision by the Court of Justice. Ricardo, once again, welcome. Thank you very much. The floor is yours.
So, good morning, everyone. It's first of all a pleasure to be here today. It's truly an honor to be at this university where I was a student and where I'm a lecturer today, and also to actually be discussing a case that I've been working on for so many years. This all started back in 2007, and this is a case that it of course brought a special relationship with his clients, and actually ended up in a friendship that we today have, and it was initiated because of this case. The Secil case, the way I'm going to present this is really taking the perspective of the lawyer. So I'm to a certain extent not that objective. I'm looking to the case and to the decision as a lawyer, and I will explain you exactly how some of the arguments that have been, of course, addressed by the court have been presented to the court, because all this relied on a specific strategy that we have for that purpose. So, first of all, the fact pattern. The fact pattern is quite easy to explain. So we have a Portuguese parent company that holds a participating interest in two subsidiaries located outside of the European Union. On the one side, we have Gabes, a company incorporated and tax resident in Tunisia, where Secil holds a majority stake of 98%. On the other hand, we have Lebanon. And in Lebanon there is a company called Cjeu, where Secil holds a direct participating interest of 28%, above 28%, and an indirect one of, I guess, 22. It's over here. It's here, 22.41. So indeed, in the two situations, Secil has a direct influence in those companies. What was the goal? The goal was it's also quite easy to explain. It's straightforward. It's basically avail of the participation exemption on inbound dividends received by Secil. So dividends paid out by two companies located outside of the European Union should benefit from the Portuguese domestic participation exemption rules. The initial thoughts about the case go back to 2007. And the participation exemption for domestic dividends for this year that ended up in the European Court of Justice, in the Court of Justice of the European Union, it is 2009. And so in 2009, the domestic rules on the participation exemption were as follows: the distributing entity needed to be subject to tax. The parent company needed to hold at least 10% stake in the subsidiary. And or alternatively to that 10% threshold, the acquisition amount for that participating interest should amount to at least 20 million euros. And then there was the 1 year holding period as a timing criteria that needed to be fulfilled in order to apply the participation exemption regime. A partial exemption, so a partial relief of 50% was granted if the conditions 2 and 3 set out in the slide were not met. And it was also applicable in case the company had not been subject to effective taxation at the level of the distributing company. So the 100% would not apply, it would apply only the 50%. So this is the fact pattern in terms of facts and in terms of the legal framework that was in force back in 2009. Well, we knew from the outset what the main argument we would be using since the very beginning. And the main argument we would be using was basically the free movement of capital. So that was like the main topic that we would be addressing. The question is, would we only be addressing the primary law, so the free movement of capital that was set out in the treaty at that moment in time? It was not yet, but I will use the present terminology. So the treaty on the functioning of the European Union, or would be using also the free movement of capital set out in additional contractual arrangements that existed for that purpose. And we as a lawyer, and myself as a lawyer, we all have always a bit of risk aversion. We don't want to put all the arguments in or all our position in a single argument. So we needed to find out or to sort out whether there was something more out there that could help us in justifying our position. And this was one of the main topics that we found that existed, the so-called Euro-Mediterranean agreements. This is something that probably you do not come across when you take a law degree. No, there is no much people that have actually studied these Euro-Mediterranean agreements. They're not even easy to find if you want to search them in the internet, in the European Union website. They're not easy to find, I must tell you that. But well, out of curiosity, we needed to look at that. So there was a Euro-Mediterranean agreement executed between, or concluded between the European Union, the member states, and that third state, so with Tunisia, and another one with Lebanon. So they were what we call, in academic terms, a mixed agreement, meaning that we have on the one side the member states and the European Union, and on the other side, the third state. Some of the clauses were actually quite similar to the ones that are set out in the Treaty on the Functioning of the European Union, which was quite peculiar. So in the case of Tunisia, I can tell you that the right of establishment and the free movement of capital were quite similar to primary law. In the case of Lebanon, only the free movement of capital, not the right of establishment. Then the question that came next was, could we actually look into those clauses and see that and take from those clauses and from looking at them a direct effect? Would those clauses benefit from a direct effect? And then we also looked, but this is a bit of an ancillary argument that we used for that purpose, is in fact, Portugal, back in 2009, already granted a participation exemption to dividends sourced in third states, as long as they benefited from a specific contractual regime that was in place, quite exceptional, only very specific circumstances that regime was granted. And actually, when we use those arguments that in practice no one was actually availing of it, was quite immaterial. The companies that were benefiting from that regime, but there was another one that was enforced since 2007 that encompassed dividends paid out by companies located in Portuguese-speaking countries, African-speaking countries, and in 2008 Timor-Leste was also added to that list of countries. So it's the Portuguese-speaking countries around the world except Brazil, and that was it. How many hurdles did we have? We had a list of hurdles that we anticipated and we listed immediately in 2007. And there were so many. First of all, would the domestic rules fall within the scope of the free movement of capital? This was one of the main concerns we had. And please note that we were years ahead of the test claimants in the FYI group litigation decision. So we were quite far away from this decision that when this case came to the Court of Justice, we were looking at it on a monthly basis just to see whether there was any update, because it was fundamental to know the outcome of that decision, to see what would be the outcome for Secil. So the interplay, and so many academic articles were written about this topic, the interplay between the right of establishment and the free movement of capital. There was so many discussion about that, so many articles being written about that. The case, what I usually call the FYI2 case, just to make it easier, the outcome confirmed our preliminary assessment is that the free movement of capital applies to participating interests where the purchaser has no intention of exerting a definitive influence on the company's decision, so irrespective of the case's fact pattern. So we need to look at the norm or the rules, not at the specific underlying facts of the case. Then the second question that arose was, well, and would the 10% threshold be sufficient, or the 20 million acquisition amount be sufficient to meet the decisive influence criteria? Again, we were years ahead of the Intel car decision and the Kronos International decision. So we had two major cases that only came up years and years later. And because of that, in 2007, we were not really sure about what the position of the court would be. But the list of questions continues. So we did have additional doubts about how would the court react to this question. Did the Euro-Mediterranean Agreement's relevant clauses have a direct effect? How would the European Court of Justice look to those clauses? Would they see those clauses direct effect? Could Secil's claim be affected by a specific clause, the so-called tax carve-out clause in the Euro-Mediterranean agreements? And I imagine that most of you are not really familiar what this means. A tax carve-out is a specific clause that both Euro-Mediterranean agreements, the one that was concluded with Tunisia and the other one that was concluded with Lebanon, have and still have, that said something like, nothing in this agreement shall have the effect of extending the fiscal advantages granted by either party in an international agreement or arrangement by which it is bound. It is not also affected by the adoption or application by either party of any measure aimed at preventing fraud or the evasion of taxes, or opposing the right of either party to apply the relevant provisions of its tax legislation to taxpayers who are not in an identical situation as regards to their place of residence. So how would we be looking at this? We could eventually come to a situation where we will look to the Euro-Mediterranean agreements, regard those clauses as having a direct effect. We were fine with everything, so there was a restriction, but at the end there was a tax carve-out and everything was set aside, and so we could not rely on those clauses on the Euro-Mediterranean agreements by themselves. So this was also a major concern for us. Then, one of more basic question, would there be any justification impairing the envisaged goal of Secil? For instance, ensure the effectiveness of fiscal supervision or any other justification? And what about the standstill clause? This was actually the first main argument we had and the great discussion about it. What about the standstill clause? So the clause that says that everything, all the restrictions that already existed, it's not exactly all, but let's put it this way just for the purpose of the presentation, but the restrictions that existed on the 31st of December of 1993, they are safeguarded from any appraisal being made by the court on a subsequent basis as long as those restrictions already existed back then. So, and in fact, in 1993, Portugal did not grant any participation exemption to dividends sourced in third countries. So there was really, the restriction exists already in 1993. So how would we overcome the standstill clause? Could that standstill clause be used and affect Secil's claim? Well, we needed to play a waiting game. And the waiting game relied on a specific litigation strategy that was, of course, discussed with Secil and ourselves as lawyers. First, we insisted in exploring the administrative route as a means of waiting for the course of justice case law on specific topics that we knew would be coming up and we could rely upon once those decisions came out. But at the end, when we had the decision on the FYI2 case that I referred back to a few minutes ago, we decided to, now, this is the decisive moment, we should explore the litigation route, not on an administrative level, but going to courts. In this case, going to tribunal, going to an arbitration tribunal. It was a regime that was quite recent back then. And we decided to move forward with the dividends relating the financial year of 2007. The reason was quite easy to explain. It was the financial year where the dividends were of a less significant amount. We ultimately had a positive outcome on that arbitration case. The case was decided on the basis of the éthique doctrine, and so we got a positive feedback. And after knowing the 2007 decision, the arbitration route was also used a couple of years later because of how the case was managed or handled with the 2008 fiscal year. Other fiscal years are still pending in tax courts. We, as I told you, received positive feedback on these first approaches of going to court or going to tribunal. Domestic cases have been decided favorably, so that the arbitration decision on the financial year 2007 and financial year 2008, although the 2008 was made already in 2016, and it already relied and made use of the Advocates General opinion. So they decided on the basis of the éthique doctrine, but already looking at the conclusions of the Advocate General. Curiously enough, and the cases on the financial years of 2005 and 2006 were also decided in favor of Secil on the basis of this specific argument. Those cases have additional legal arguments that were used in the claims, but the tax courts decided in favor of Secil based specifically on this argument as well. But all decided after the decision of the arbitration tribunal relating the financial year of 2007. So this is quite of an interplay to have so many financial years, and financial years from 2005 and 2006 were actually decided after the decision on the financial year of 2007. But that's the particularities about the Portuguese regime. And at the end, we were quite happy with the decision of the European Court of Justice. And the decision of the European Court of Justice addressed a lot of those questions that we anticipated would be the key things that needed to be ascertained from a legal standpoint. And the first one of all, we were already quite confident on this one. This was that the free movement of capital was applicable, and particularly because of the FYI2 case that I referred back to you. Then a restriction was found to exist. That's the conclusion on that. The standstill did not apply. And why does not the standstill apply? Because of the Euro-Mediterranean agreements that were concluded by Portugal, the European Union, and such third states, and they were all concluded after 1993. So we have the one with Tunisia being concluded in 2000, and the one with Lebanon being concluded in 2002. And so because of that, the standstill clause is set aside. The European Court of Justice looked at the mixed agreements, so the Euro-Mediterranean agreements, and regarded them as an internal law, exactly equivalent to that basically changed the regime to those specific countries, and as such, Portugal could no longer rely on the standstill clause. Secondly, the Court of Justice ruled out the justifications regarding the need to prevent tax fraud and evasion of taxes. So it's in a couple of paragraphs that the court is quite clear on that, just setting that cause of that justification basis aside, but admitted a justification concerning the need to ensure the effectiveness of fiscal supervision. And how would that work? It only applies for the full participation exemption regime. It does not apply for the partial exemption regime, so for the 50% partial exemption that I referred at the beginning. It ruled out specifically the tax carve-outs of the Mediterranean agreements. So they looked into that particularly. This is like one of the first cases they do that in relation to Mediterranean agreements. They took an approach that had already been used for other agreements. Full participation exemption is then dependent on the satisfaction of a condition of tax liability of the distributing company. So we need to ascertain, for the purpose of the full participation exemption to be granted to Secil, there's a need of collecting evidence that the distributing company is subject to tax in such jurisdictions, and the Court of Justice goes really into the details and says, well, in relation to Tunisia, and since there is a double tax treaty with that was concluded between Portugal and Tunisia, it can probably rely on the exchange of information mechanism that is set out in the agreement, and the Portuguese tax authorities can, from the outset, I would say, most likely can and it shouldn't be that difficult to obtain that information from Tunisia. And of course, indeed, the Gabes, the company in Tunisia, was subject to tax in Tunisia. As to Lebanon and the Lebanese Republic, what the court says is that the justification by the Portuguese tax authorities and the Portuguese courts can only be applied if it is proved to be impossible for the Portuguese tax authorities to obtain such data from the Lebanese Republic. And so here the question is, what it would be like. Let's see that and emphasize the fact that the court puts the burden on the impossibility. It's only if the tax authorities deem as impossible to get that evidence. So it's quite a burden of proof for the Portuguese tax authorities to say, well, we cannot get that information, but they need, in order for them to say that, it needs to be confirmed that it was impossible for them to collect that information. So it's kind of a qualified burden of proof that needs to be complied with. Landmark decision for Secil. This is a photo that I took with Fernando Araújo. That was the person that, since the very beginning, was thinking this case with myself. And we took this not actually when we got the decision. This was when we went to the court to listen to the Advocate's general opinion. But this was taken in relation to this case. So we were quite happy with the outcome of the Court of Justice. The approach that the Court of Justice took was for us consistent with the previous case law from the Court of Justice, and on top of that, I think it was like a question of fairness and justice that was given to Secil. So, and that's the reason why, not only as the lawyer of the case, but also as a lecturer and as an academic, I'm very happy about the decision.